treasurer or fiscal officer of the county. The subcommittee requested, and I agreed, thought it was a very good change to add to the end of that original original bill, that those fees should be remitted within 30 days of receipt. A good change, and I thank the committee for that insight.
All right, thank you, sir. And this came to you by what purpose as far as having this change made?
Representative Atwood, who was involved in carrying that forfeiture bill, just asked that I carry this bill to help get this language on record.
And we have questions from members of the committee, I believe.
Thank you, Mr. Chairman. Representative Jones, I just want to make sure I understood a statement you made just a second ago. You said this is the fixed mistake that Representative Atwood made, Chairman Atwood made.
I don't believe I said that. Now, did I?
I thought that's what you said.
We
this
replay
is
the tape. This is cleaning up from a very complex bill, language that was inadvertently left out due to just, I think that the sun was in his eyes that day or something.
I just wanted to make sure. Thank you.
Anything further from members of the committee? Thank you.
Thank you, Mr. Chairman.
Have further input from anyone in the audience? Anybody else who can speak on the bill? Yes, ma'am. Come on up here and have a seat.
Deborah Nesbitt with the Association of County Commissioners. We actually asked Representative Atwood to do this correction. It was just struck in some revisions of that code, and we just wanted to have it put back in. And we support the 30 days because the clerks do it the same way. Thank you.
All right, thank you. Anyone else wish to speak to the committee? If not, we'll close all further input from the audience, and the bill is now in the address of the committee. We do have a motion, and the motion is to pass. Has been seconded. Do we have any discussion on the motion? No further discussion. Chair will call the main question, which is to pass House Bill 228 as a committee substitute. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries.
Thank you, Mr. Chairman. Thank you, committee.
There you are. Take your bill up next, which is House Bill 405. Anyone you want to bring up with you, or
I'm going to present by myself for now, Mr. Chairman, if it's all right.
tell us about House Bill 405?
Yes, sir. Ladies and gentlemen of the committee, I bring you HB 405, which is part of the State Bar of Georgia legislative initiatives for 2015, carried over from 2015. Comes from the family law section, and I'll just go ahead and introduce Pilar Prinz, who's sitting back here on the first row. She is our new legislative liaison this year for the executive committee of the State Bar, and beside her is Chase Wilson, who those of you who are on the subcommittee heard from Mr. Wilson. Pilar practices here in Athens with Lawler Prinz, and Chase practices with Davis, Matthews, and Quigley. This piece of litigation would require that, first of all, it would define antenuptial agreements, also known as prenups, which is not currently defined in the code. It also would require that antenuptial agreements be in writing and attested by at least 2 witnesses, one of whom must be a notary. And so in trying to address a statutory framework for antenuptial agreements, it's important to note that prenups had been authorized by case law. A case called Shearer versus Shearer in 1982 had authorized and allowed the enforceability of prenuptial agreements. And so in finding a place in the code, the court in case law had also discussed the concept of marriage contracts, which is in this code section that it's dropped into. And there had developed confusion in the case law about contracts made in contemplation of marriage and contracts made in contemplation of divorce, and different attestation requirements associated with those formalities. So Thus began what started out as a somewhat simple process to try to put this definition in code, and became a little more complicated than that, as these things sometimes do, because the historical origin of this code section dates back to a time when women could not own property, and predates the enactment of the Married Women's Property Act of 1866. So in dropping it in, I'll just walk through what the bill does, page by page, page by page. On page 1, marriage articles, which is a concept that's being removed. It's an antiquated concept that's being removed from the code. Were allowed as an exception to the statute of frauds. So this strikes that exception to require that, to eliminate that requirement, since we're eliminating marriage articles. On page 2 is where the definition, lines 32 through 35, where the definition of antenuptial agreement is. There was a subcommittee substitute that made some tweaks to that definition, and so that is where it's now contained. Lines 45 through 48 talks about the formalities required in the execution of the antenuptial agreement. And then the remainder of the bill changes, again, repealing a lot of the code section related to this concept of marriage articles, which is being removed. And so, Mr. Chairman, I'll, of course, answer any questions anybody might have about the subject matter, but I do want to, even though he's not here, Chairman Welch asked a specific question about lines 81 and 82, and specifically the changes in 19.366. And I don't know if I see several members who were present in the subcommittee. I promised an answer on that. If everyone still wants a burning answer to the issues we were talking about, I'm happy to go through those next, however you'd like me to proceed. Yes, sir. He had a question related to the, first of all, subparagraph B begins talking about antenuptial agreements may be enforced by a court of equity, and that is the way it's raised. It's a motion to enforce. The court does sit as a court of equity, which is important in answering the question. But his question was, if there was an agreement that was entered into between the now spouses that did in fact affect the rights of third persons, purchasers, or particularly creditors without notice, would that affect the enforceability of the agreement if that were true? In other words, would it destroy the intention of the spouses if that had been the effect? And we were talking about the example of a piece of real estate, perhaps, that had been assigned to one spouse in the event of divorce, but perhaps during the marriage there had been a mortgage attached to the spouse, and now we had a creditor and the rights of a creditor intervening. The committee took a look at this question, and also I had a conference with Ms. Travis, and I think the general consensus is that it would not affect the enforceability of the agreement, because you can't do anything that would be that would violate the Uniform Fraudulent Transfer Act. If the committee is concerned about that, I think it could be fixed and addressed and clarified. If you feel it needs to be clarified, by simply saying a spouse at any time during the life of the other spouse, subject to the rights of third persons, purchasers, or creditors, and then semicolon there. And I think you could address it and make it crystal clear if you wanted to make it crystal clear. And so with that, Mr. Chair. Yes, sir. So that it would read, a spouse at any time during the life of the other spouse, subject to the rights of third persons, comma, purchasers, comma, or creditors, in good faith, semicolon, or, and then it goes down to 3. So I think if you want to be crystal clear about that, then that would take care of it.
Any questions of the presenter, members of the committee? Let me ask you, we talked about this the other day briefly. There got, I think, a clear resolution on it, and that was we're having this signed by two witnesses
The policy and discussion, at least in the committee itself, Mr. Chairman, revolved around whether or not to use may or shall in this sentence. I think the feeling was the previous statute required 2 witnesses. We wanted to require 2 witnesses. Should we require a notary? With a couple of things. One is almost always someone is either determining or talking about dealing in the future with the agreement addresses real estate. If somebody has the money to do a prenup and the inclination to do a prenup, usually you're dealing with some real estate interest that are involved. But as importantly, too, in this advent of form-driven society and people doing their own legal work, we felt that having that extra step of having a notarization of that somebody's signature is someone's signature was at least some extra help in that step, albeit, perhaps debatable, but helpful. And so that was the policy discussion between the may and the shall. But we're not invested in shall, but that was the reason it was selected.
Mayor Shaw, I like to have 2 witnesses.
Yes, sir.
No question, the witnesses, I think, are appropriate in this case, so that later says, well, whatever you're going to say, either I didn't sign it or didn't know what I was signing, you had witnesses who please testify what their recollection is. I just wondered why we're wanting to make the requirement of a notary, and even if you talk about, yes, deeds of conveyance is required, and they require it for reason of recording. This is not like a contract with real estate. That doesn't require a notary. This is a contract as to what may be eventually bringing about a conveyance of real estate, but that conveyance is done by a separate document.
And I think only if there were a dispute that you needed to record something, obviously, in the deed records pending the resolution of that dispute, there could be some theoretical circumstances under which it would become an issue that it is a conveyance of real estate. But just out of an abundance of caution, that was the feeling of the executive committee.
Other questions? Anyone else wish to ask questions of Mr. Gunner? I see none, but we have others who would like to speak. We got a sheet. You have a sheet, brother. Thank you. Please come up. We have on. Have a seat with
Thank you. Good afternoon. Yes. Yes, my name is Pilar Prinz. I am the legislative liaison of the family law section of the bar. I am a partner at the law firm Lawler Green Prinz, and my practice is exclusively in the area of domestic law. This bill, HB 405, actually came about in our family law executive committee meetings a couple years ago. The section had noted frustration with, it stemmed really out of a couple Supreme Court cases. There were 2 cases in particular where the court focused on the distinction between these agreements made in contemplation of marriage and those made in contemplation of divorce. Most notably, although there is a difference between the 2, and that in and of itself isn't a problem, it's that, as Representative Quitt pointed out, that there are different attestation requirements. As of right now, an agreement made in contemplation of marriage, which the short distinguishment between is that one may make a provision for alimony and the other does not. An agreement made in contemplation of marriage requires 2 witnesses under the law, and an agreement made in contemplation of divorce does not. In 2009, the Dove versus Dove case noted that what we refer to as prenuptial agreements, which cover all these issues in the event of a divorce, actually has no no witness requirements. There have been cases where that became the turning point on whether an agreement was going to be enforced or not. And as a practitioner, I have actually litigated this issue and spent countless number of hours crafting the argument and having to have the distinction made to the judge whether this was an agreement made in contemplation of marriage or one made in contemplation of divorce. it didn't seem to the family law section that that makes a lot of sense today, because this original contemplation of marriage articles, which we're seeking to remove, is a 150-year-old provision. Prenuptial agreements or agreements made in contemplation of divorce have now been allowed in Georgia since 1982, yet we haven't updated the law so that we have the same attestation requirements between these two types of documents. And that really is what we're seeking to do. Prenuptial agreements are litigated constantly. I can't think in the 15 years that I've been practicing family law of a time that a client has ever come to me and said, here's my prenuptial agreement, my wife and I both agree, just turn it into a settlement agreement and we're done. In fact, they are litigated, it seems, to the nth degree, just as much as if they didn't have one. And for that reason, we take great pains in drafting them to make sure that they are as enforceable as possible, but they're also very significant documents because people are potentially waiving rights that they otherwise might have had under the law. So there really are two reasons behind this from the family law section's point of view. There shouldn't be a distinguishment of the attestation requirements between the two, and we feel that they're serious enough that they should require to both be in writing and have two witnesses. And I'll speak to that. I agree with Representative Quick. It would be the section's preference. We did go back and forth. I don't think we feel it's not certainly a necessity. To your point, though, there is one distinction between a divorce settlement agreement and a prenuptial agreement. In a divorce settlement agreement, it is going to be almost immediately taken to the Superior Court judge and entered as an order, where a premarital agreement may not be viewed by a court for many, many years to come.
Does it bring about a concern or reservation for you as an attorney advising clients on doing prenuptial agreements under current law? That is very enforceability usually reviewed by a court.
We, as a matter of practice, have every prenuptial agreement notarized, witnessed. We kind of belt and suspender it.
I'm asking about clients coming to you, or a client does, and wants a prenuptial agreement to get married, and you withdraw the agreement. Are you capable of telling that client today of the enforceability of this document by the court at some future time because of the uncertainty we have in the law?
Yes. I mean, there's certainly never a guarantee, and I tell clients that, but I explain the factors that the law is required to look at and what our body of case law, which is fairly substantial, has shown us so far. So yes, and we explain the requirements.
Whatever the facts before them sway one way or the other as to what will be the interpretation of those agreements?
I haven't found that to be the case.
I'm thinking of the employment agreement, covenants, containing employment agreements about not to work or something, the limit at which your future working would be, and that was an ongoing concern for many years until we found a few years back passed a constitutional amendment. First of all, we passed a law to sort of clarify that area because you had agreements reach the appellate level, depending on whatever the facts were about businesses or the type of employment, or they kept changing, swaying with the tax position, where you had to tell what would happen with one of these agreements for it to be sometime in the future reviewed by a court.
Mr. Chairman, I'm going to take your question to be asking that, and you correct me if I'm wrong, whether or not the Shearer test, which is in case law, needs to be set forth in a statute for clarity. And I would say my answer to that would be no. I think the test is clear. In fact, our discussions in the committee were that our case law in Georgia was a bit more predictable, in our opinion, than the Uniform Act, which we looked at as a possible suggestion for this issue. But the key and the linchpin in Georgia is full financial disclosure. And so
right.
that's really where I think that what you may be thinking of are some cases.
Part of that. There have been cases, I know, dealing with the whether or not you made a full and appropriate financial disclosure, and then if the one court decides no, that wasn't done, then you're going to have a set aside of the entire agreement. Another court may say, well, that's sufficient, and it may have been oral parts of it, so you get some varying degree of the court's interpretation.
And in that way, Mr. Chairman, it's not like a motion for summary judgment. There will always be a hearing, and portions of this will always be a factual inquiry as to whether or not the test is made, so you'll get those results.
Any other questions by members of the committee? All right, thank you both. Is there anyone else who would wishes to speak before the committee on House Bill 405? If not, we will close all further public input. The bill is now in the breast of the committee. Do I have a motion? Been a motion to do pass. Is that seconded? We have a second. Is there discussion on the motion? No further discussion. We'll call the main question, which is a motion to do pass of House Bill 405 as a committee substitute. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries.
Thank you, Mr. Chairman.
Thank you.
Pleased to have all of you with us. Representative Tanner, there you are behind the pole. We're going to have next House Bill 691 by Representative Tanner, and this is addressing municipal courts. Thank you. Go ahead.
Thank you, Mr.
Tanner.
Chairman. I'm working from LC 296852 ERS. This was a committee substitute.
Correct.
In essence, Mr. Chairman, this is a bill that came about with a process that started last session. The municipal court judges in the state wanted to start a dialogue with GMA to try to create a way to where there would be calls when a judge was going to be removed from office. Municipal court judges are the only judges in our state who work for the other branch or the executive branch of government. They're non-elected and they work for the executive branch of government. Municipal court judges under current law can be appointed to serve by a municipality for a term, or they may just be appointed and then they can be removed for any reason or for no reason from serving in that position. Certain communities, municipalities, have a charter or an ordinance that guides this process, but most do not. This bill is taken us some time working with GMA and municipal court judges to come up with an agreement that all parties have agreed to and that all parties are comfortable with, and I believe they testified to that in subcommittee, Mr. Chairman. In essence, one change that the chairman of the committee had asked for that we made was that the term will be set at a minimum of 1 year. That term will be in writing or by ordinance or by charter, but it can be no less than 1 year. If on lines 27 through 37, it deals with the cause that the individual judge could be removed from office. And in essence, what would occur if a member of the city council believed that the judge had done something that resulted in removal from office, they would notify in writing, and the council would hold a public meeting, and at that public meeting it would take a majority vote to agree that they needed to move forward with a removal proceedings, and that removal proceedings would be conducted, and a 2/3 vote would have to be obtained before the judge could be removed from office. During the time that between the first vote that takes place with the majority vote, the council could suspend the judge if they feel it necessary. During that suspension process, the judge would be compensated and paid at his normal rate. During that suspension, the city would be able to go out and get a temporary judge to fill that vacancy. If that decision was not made in that 60-day window, then the judge would be placed back on the bench. So they would be able to suspend up to 60 days during this process. If the judge was unhappy with the outcome of the decision by the council, he would have a right to appeal to Superior Court, and all those rules would apply. This also has no effect on the Judicial Qualifications Commission, so that they would still be able to take action against the judge if they violated a rule that they felt like they needed to move forward with some type of disciplinary action. Mr. Chairman, that's in essence the bill. And again, I want to thank the Municipal Court Judges Association and GMA for working hard to come up with this resolution that I believe all parties are comfortable with. And I'm happy to answer any questions.
Thank you, Representative. Any questions of Representative Tanner? Your button's not working? There you are. Go ahead, pull around.
Representative Tanner, what precipitated this bill?
Municipal court judges started a dialogue with both me and GMA. There's been several cases, and I know the municipal court judges are represented here and could speak to this, where a municipal court judge came in to sit on the bench and to have court, and there was another judge that had replaced them. They had been removed from office. I know that municipal court judges associations actually had presidents of their association that's not been able to continue service because they were removed from office with no cause given. So there was a dialogue with GMA and municipal court judges to create a more professional process for protecting the judges from political processes on the bench.
Okay.
But there wasn't one single incident that started this conversation.
And as I reflect on it, I don't know of any other judgeship in Georgia that doesn't have terms of some form.
That's correct.
That's
I
correct.
mean, starting with, magistrates, probate judges, state court judges, recorder's court be somewhat similar, but they have, I guess, I don't know if recorder courts, very rarely you find them anymore, but there are a few around still. All of them have terms of some form, right?
Yes, Mr. Chairman, and I think even you pointed out that magistrates, associate magistrates who are appointed also have a term, even though they're unelected.
Correct. Do you want to introduce your judges with you?
Go ahead.
I'm Leslie Jones. I'm the judge for the Municipal Court in Athens, Clark County, and I serve as the president for the Council of Municipal Court Judges. We thank Representative Tanner for sponsoring the bill. We appreciate y'all's time this afternoon. We're happy to answer any questions that you may have. I'm joined today by Judge Gary Jackson from City of Atlanta Municipal Court.
Yes, sir.
I'm one of the associate judges, proud to work with Judge Jones. This bill, Mr. Chairman, members, is part of an overall thinking of the Municipal Court Judges Council to professionalize our membership. This committee and the House and Senate has already passed recently bills that all new judges must be lawyers. We have other bills pending dealing with attaining the status of court of record and prosecutors, and we are attempting to professionalize ourselves and have a full, real court that can meet the needs of Georgia citizens. And this is just one aspect of that plan.
All right. Thank you, Judge Jackson and Judge Jones. Is there anyone else who would like to? I think Mr. Patel. Yes, sir. You. Why don't you come up here and have a seat? You can
I'll
use
yield
it.
to the GMA.
All right.
Rishi Patel with the Georgia Municipal Association. I just wanted to thank the municipal court judges and Representative Tanner for working with us on this. And I might add to your comments, Mr. Chairman, that all new cities actually also have to have causes of action in their municipal courts as well. So this is actually bringing all other cities into line with any new cities created. So
How do you mean?
it's kind of a causes of action to remove their judges. It's kind of an interesting little quirk in the Georgia Constitution in Article 6, where it says all courts fit into this category except for municipal courts created before 1983. So
All right. Well, we, speaking of one city, Sandy Springs, we recognize that the removal judge comes under the auspices of the Judicial Qualification Council. So if they do something that's in violation of the ethics of judges, that's where they would be removed. And we really hold them separately from the rest of our ethics ordinances because of that. They are in a separate role.
Right.
But
As
it's a good
they should
point.
be.
They should be, yeah. Okay.
But this bill would also give your city and other cities other avenues that are listed in here and could operate independently of the JQC and city council mayor so far.
All right. Of course, it's not optional. It's a mandate in here, so general laws will override that charter provision that we currently have. Just making that point clear on that. Thank you. Anyone else wish to address the committee or any further questions of members? Yes, sir. You have a question over here. Who was that? Ms. Jones, excuse me.
Thank you, Mr. Chairman. I asked a little bit of this question yesterday. Help me, we've seen in current events where the public has been highly unhappy with decisions of some of the courts, as is usual. I just want to make sure that this bill is not going to put any cities or places in a circumstance where a judge does something that is highly inappropriate, gives a bond amount in a really bad case, and then we have people protesting like this is Ferguson or anything of that sort.
Well, I think one thing we have to keep in mind is the municipal court judges are handling lower level offenses for the most part. So I don't think we would have a situation like you're referring to in a municipal court. However, this does not tie the hands of the municipality if the judge does do something that the council feels is grievous. They can take immediate action by holding a public meeting and suspending the judge with just a majority vote. That will give the judge an opportunity to have an official removal proceedings where they would be able to present evidence. Evidence would be presented against them, and they would have a right to appeal that to Superior Court, and it would require a 2/3 vote of the council. So no, if the council still has that control to remove the judge if necessary, even in a very quick manner, at least for suspension purposes. Thank you.
If I may add as well, Representative Tanner, Representative Jones, one of the things that the bill does do is allow the city to describe and create for-cause reasons beyond those that are in the bill. So if they wanted to, they could include in their charter what might be a for-cause reason for removal. Once it's accepted into the charter, then that would become part of the terms that the judge would be subject to. So it would still allow that municipality within its locality to define what's important to the locality.
Anything further from any member? Anyone else wish to address the committee on this bill? House Bill 691. If not, we'll close off further public input. The bill is now on the breast of the committee. Do I have a motion?
Do pass.
Motion is due pass. Do we have a second? It's been seconded. Any further discussion on the motion? If there be no further discussion, Chair will call the main question, which is a due pass to House Bill 691 as a committee substitute. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. So we got to pass.
Thank you
Mr.
so
Chairman.
much.
Thank you. All right. Last bill we have is House Bill 759, of which the chair is the author of it, and I will ask Mr. Fleming as vice chair to chair this portion of the committee. Get you, Michael. There we are. Excuse me.
Okay, before us is House Bill 759. Mr. Chairman, you want to go ahead and present that to us?
Yeah, please. I'm going to ask young lady come up, Brandy, to have a seat, if she will, since she is the one that brought this matter to me. And what we have is a provision in law under Title 15, Code Chapter 19, Section 52, which is an old section of law, but it recognizes that previously, at least at the current time, I should say, banks may, in the providing of services and financial services and investment services, etc., can do so without the fear, we'll call it, of that being considered the exercise of prerogatives addressed to lawyers and reserved to lawyers and practicing attorneys. And so the bill was being asked to be changed to financial institutions, so it would also include the credit unions. Banks, on the most part, for many years have widened the services they provide, and certainly the credit unions have done likewise, whether it be providing investment counseling and forms of 401k accounts and what to do with them and how that's to be handled. So they were concerned that they're not included in this, and they wanted to have that law modified. And if I may, I'd like to have Brandy, if you will, to introduce yourself and give us some more information.
Thank you, sir. Brandy Bickle, Georgia Credit Unions. On behalf of our credit unions, thank you, Chairman Willard, for bringing this bill forward for our industry. We appreciate the time of the committee hearing the matter as well. I know it seems like a small bill, but it's a big issue for us. And what we're looking to do is we're looking to clarify the law to ensure that the way that we've been treated for years as being considered in this exemption, that that's what the law actually says. We're not looking to expand the exemption. We're not looking for new powers. We're not looking for new abilities, new capabilities, you name it. We just want to make sure that the letter of the law is how it's actually being applied today. So we appreciate you guys' time, and we ask for your favorable consideration of the bill, and happy to answer any questions as well.
So basically, Ms. Briggle, what we're doing is that we're taking an existing code section that covers an area to make sure that banks can give advice on, I suspect, closings and other things like that. Let's see. Yeah, matters incidental to providing financial services. So anything dealing with borrowing or lending of money, I guess.
Not from correct.
Right.
We're not looking to expand into the mortgage lending, if you will, because you need an attorney on the mortgage lending front. But if we're doing our auto loans that we're doing every day, if we're sitting in front of a member, encouraging them.
So currently, it's already in the code that banks
Correct.
are exempt from any problems with that, and we're just simply adding in credit unions. Is all we're
Correct, sir.
doing. Yeah.
Correct.
Okay.
Correct.
Any
Federally
questions?
insured.
Go ahead, Mr. Chairman.
I would say it even goes to the point of recognizing the drafting of a note, which is a legal instrument, the drafting of collateral agreements, which are maybe considered legal instruments. That this is not a practice of law by those persons and the institutions previously saying as to banks. This is what also is done in credit unions, but they're not under the definition of our law recognized as a bank. They are recognized under definitions as a financial institution. So we felt, as she brought to my attention, it would be appropriate under the day's economy and way things are handled that credit unions also be included.
Thank you.
Any questions of Ms. Brickle or the chairman on this bill from the committee? Anyone else here wish to speak to the matter? If not, we'll bring the bill back to the committee. And is there any motion or do pass? Second. Any further discussion on the bill? Hearing none, all those in favor indicate by saying aye.
Aye.
Any opposed? Bill passes the rules, Mr. Chairman. Good luck.
All right, thank you. Still do the Senate with it now. I've got a reputation over there to defend. All right, we have no further business as far as bills coming before the committee. Anyone have anything they want to bring up to the committee at this time? If not, we will stand adjourned. Thank you.